lawyers. What were the most absurd questions the judge allowed you to ask? Story 1. Ha! I'm a lawyer. I should win right there. Anyway, we were in trial, and opposing counsel was objecting to a document I was trying to enter into evidence through one of their witnesses. The witness had identified it as one of their business records, but opposing counsel objects. Jury is in the courtroom, so the judge has us approach. We do, and opposing counsel argues the authenticity of the document. I was a little surprised, so my response was, Your Honor, this is their exhibit. Is counsel stating they submitted inauthentic documents to this court? Judge turns to counsel. Are you submitting non-authentic documents? Opposing counsel stammers out a no, and the document goes in. I was a little surprised they wanted to argue their own document wasn't authentic just to keep me from getting it to the jury. Story 2. I'm a lawyer. The state tried to argue that probable cause exists simply because there is a police report alleging the crime. From the fact that a police officer filed this report, it is a reasonable inference that the crime took place as described. Good, allegations are self-proving now. Well, wrap up court then. I guess no need to hear any more motions to dismiss ever. I wonder why no other prosecutor in 240 years of jurisprudence ever thought of that before. 25-year-old assistant district attorney who went to the worst law school in this state. Story 3. I am a lawyer. Had a female inmate claim she was molested by one of the guards. One of her most damning pieces of testimony was testifying to this large vertical scar he had on his chest from a heart operation. She continued to say that she remembered this huge scar from when he molested her. The guard got on the stand, took his shirt off, and he had a tiny horizontal scar up on his shoulder. Case over. He had apparently told her one time that he had surgery, and she assumed it would have left his giant scar and used that to make up her story. Edit. To clarify, I was a new clerk for the judge when the trial started. I don't know exactly why this didn't come out in discovery. My guess. Plaintiff's counsel were 2 years out of law school, appointed to the case, had only done corporate law, and were from a monster New York City firm, so probably didn't give it any time. As for the defense, either the Department of Corrections wanted to publicly humiliate the inmate, people make a lot of dumb decisions based on a screw you mentality, or defense counsel wanted to get that trial money. Story 4. Actual lawyer. What I dub the surprise party defense. In a hearing for an order of protection, in which ex-wife is trying to get an order of protection against ex-husband who had been stalking her. They have a high school-aged child together. Ex-husband tries to argue against the order of protection by saying they may need to be able to communicate about the child. The judge points out that they can communicate through the child, and also that other family members have been put in place by the juvenile court to be intermediaries re pick-up, drop-off, etc. Then ex-husband has a brilliant light bulb idea. Judge, what if I need to throw my son a surprise party, and I need to keep it secret from everyone, but his mom still needs to know so she doesn't throw a party the same day? In other words, while I admit have been stalking my ex-wife, and that there are grounds to grant an order of protection, you should not grant that order just in case I need to throw a surprise party one day. What made it was how clever he thought the argument was. Thus was born the surprise party defense. Edit. A lot of you are upset about the comment of communicating through the child. That was probably a poor way to phrase it. In this situation, the father would be barred from passing messages to the mother through the child. He can't say, tell your mom X, but, of course, some indirect communication. Story 5. Judge had a very firm rule during expert witness testimony that the expert could not testify beyond the scope of their expert report. During my expert's testimony, I snuck in some new testimony that was not in my expert's report, but was arguably an extension of an opinion that was in their report. If the other side objected, I was ready to either go without it or make some kind of argument for why it was within the scope of their report. But the other side didn't object, so I got it in clean. When their rebuttal expert stands up the next day, during part of their testimony, the opposing counsel begins to ask them questions to rebut the new opinion my expert had just delivered yesterday. I stood up and almost couldn't keep the smirk off my face when I objected to this testimony as not within the scope of their expert's report. It couldn't have possibly been in his rebuttal report, because it was responding to a new opinion that my expert only delivered on the stand. Objection sustained. Story 6. Not an argument, but a funny moment on cross during a bindover. Before law school, I was a detective in a metro area. We worked a string of burglaries, and the very distinct-looking suspect was preliminarily identified by another detective. I did surveillance on him, and indeed he looked identical to the person on camera during the burglaries. Wrote up a PCA, probable cause affidavit, and he was eventually arrested on a warrant for burglary to a dwelling. We had other evidence, but my identification of the suspect was foundational. On cross. Defense. So you testify that you identified my client by his distinctive nose and glasses? I have a nose and glasses, the judge has a nose and glasses, so couldn't that be us on video? Or anyone with a nose and glasses? Me. Well, the defendant has a nose like a windsail and glasses thick enough to burn ants on a sidewalk. When he walked out of his trailer, I saw his nose first, and it was pretty unmistakable. You don't forget a nose like that. Defense. Underscore, trying to hold back laughter, and eventually failing in that endeavor underscore. His client looked so mad at him after that. Story 7. I distinctly remember what is probably the first time that I became truly disillusioned with judges. I was working as a law clerk at the time. We had a pretrial on a civil case that was going to trial. Business fraud case. I was tasked with going through the parties' discovery requests and summarizing them. One party had a standard stock boilerplate motion that included a request for, quote, any and all relevant health records. There were no health records in question. So I wrote in my memo that it was a boilerplate motion and that there were no medical records at issue. The next day I had the following discussion with my judge. Judge, I have to say I'm rather unhappy with your work on this memo. Let's take a look at this. You say that it's a boilerplate motion and that this isn't an issue. Why would they file a discovery request for something if it wasn't at issue? Me. Well, Judge, it's identical to the omnibus discovery motion that they filed in every other civil case in your court. Judge, no attorney would file the same motion in every case, and certainly not. Insert prestigious lawyer's name here. You must be mistaken. Me. Judge, it's a fraud case. There are no medical records. It's irrelevant. This is a simple question of whether agreement to the contract was obtained via fraud. Judge, well, you must be wrong. I hope you're happy. I'm going to have to spend all night reading these motions again. Cue the next day. Discovery hearing. Judge pulls up the motion that I flagged. Judge, all right, counsel, I'd like to go over this discovery request line by line. Now it says here that you're wanting medical records. What medical records have you not gotten? Prestigious attorney, with shifty eyes. Your Honor, we haven't received any medical records. Judge turns to defense counsel, who is less well known. Why haven't you given him any medical records? Are you sandbagging? Other attorney, oh no, Your Honor. There were no medical records to turn over. Judge, to first lawyer, so, do you need any medical records? First lawyer sheepishly, no, Your Honor. We make that motion in every case. Judge, clearly very angry. Well, I have here an 80-line item request for discovery. Are you telling me that you file this list in every case? Attorney, yes, Your Honor. Judge, your motion is denied. Hearing adjourned. She walked past my open office door more quickly than I had ever seen her walk before. No eye contact. Never heard about this incident again after that. Story 8. Sat in on a personal injury case where the plaintiff broke their leg in an accident and had a doctor on the stand as an expert. The woman's lawyer begins questioning the doctor about their experience with leg injuries. He was a well-known orthopedic surgeon in the area. She asks if he's ever treated a tibula fracture. The leg bones are tibia and fibula, to which he only answers no. Then she starts grilling him with questions about the tibula. After about 6 to 7 questions, she asks, "How did you get a medical license and have been able to practice medicine this long if you've never treated a tibula fracture?" And begins a small rant about going after his credentials and those that gave it to him, to which he simply responds, "There is no bone named the tibula." The lawyer became beet red, and everyone in the room tried their best to keep from laughing, including the judge. Story 9. I was involved in a pretty messy custody case. The other party was a mess and had kept the child from my client for a few weeks. OP, opposing party, was playing lots of stupid games and kept requesting continuances. I requested a substance test, which the judge ordered. However, the OP didn't show up for it. To clarify, he did show up. He just stood in front of the toilet for literally 2 hours and claimed he couldn't pee. I was representing the plaintiff, so the burden was on me. I called multiple witnesses that testified to the defendant's substance use. So opposing counsel decides to call their client for direct examination and asks, "You don't use heroin and crack, right?" That is, for the non-lawyers, a very stupid question for many reasons, especially considering his client didn't show up for his substance test. However, I fully expected the defendant to just lie and say he was clean. After the question was asked, there was a really long pause, and the defendant said, "Yes, I do both of those substances." My head almost exploded. I didn't ask any questions on cross-examination because I didn't want to muddy the waters. I won, and the child is doing great. Story 10. One of my law professors was telling us about the stupidest question he's asked, and how it only worked because the plaintiff was stupider. My professor was representing a store that had a somewhat sketchy parking lot. This one intersection could really use a stop sign, and this woman drove past the intersection without yielding/stopping and got in an accident. She sued for negligence. My professor asked her in court, "Would you have done anything different if there was a stop sign on your street before the intersection?" She answered no. Story 11. Attorney, so even though you didn't see it happen, you took another officer's word for it and arrested my client. Officer: Yes. Attorney: Do you have a locker at work? Officer: Yes. Attorney: Is that locker inside a restroom and changing area inside this very building? Officer: Yes. Attorney: Do you have a lock on your locker? Officer: Yes. Attorney: Why would you need a lock on your locker in a changing room inside of a courthouse if you truly trust your fellow officers? Officer: Sometimes defense attorneys come in to use the restroom. Story 12. I represented a girl in an aggravated assault case. Got her a really good deal where the lead charge was dropped and she'd plead guilty to lesser charges and do 6 months on house arrest with electronic monitoring, and the ankle monitor also had to have an alcohol sensor. 1 month into her sentence, I get a call from her landlord saying she was arrested for a probation violation. Her ankle monitor detected her away from her house and that she had alcohol in her system 2 separate times, and it alerted her probation officer. I talked to her at the jail and asked her what happened. She acted like she had no idea why she was there. Her mom had just gotten out of the hospital from surgery and needed someone to watch her, so she emailed her PO probation officer and asked if she could go to her mom's, and then just went. Few hours later, the PO responded and said she couldn't go, so she went home. Also, she had wine with dinner on 2 separate occasions, so it's not like she went out drinking or anything. None of it was any big deal. I was stunned by how nonchalant she was about it. I read her the riot act. There is one rule when you're on house arrest. Don't leave your house. You left your house. There is one rule when you're on an alcohol monitor. Don't drink alcohol. You drank alcohol twice. Her PO was recommending she be taken off house arrest and serve 6 months in jail. I told her the judge would probably accept that recommendation, and there wasn't much I could do about it because her violations were major. We go to court for her resentencing hearing, and I beg the judge to give her something less. I highlight all my clients' positive qualities as reasons to grant leniency, along with the fact that she admitted her violations and was very forthcoming with her PO about it. The PO then piped up when I asked her about the alcohol violations. She said she didn't know wine was alcohol. The judge was considering giving her a minimal sentence until he heard that. Completely blew apart my argument. She was open and honest. Story 13. I watched a public defender stomp out of the courtroom after his client was dumb enough to insist on testifying in his own defense. I'm sure he thought what the defendant had done was dumb. I didn't agree. I may be the only one. Maybe not too. Here's the story, written up on Reddit 2 years ago. I was a rural prosecutor. I had a DUI, driving under the influence trial. Seemed cut and dried. Nothing wrong with the BAC, blood alcohol content test. The people's evidence was sufficient in every way. The defendant was represented by the public defender. When I finished my half of the trial, the PD stood up and said they had only one witness, the defendant. He got sworn in, and the PD said, "Why don't you tell the jury your side of the story?" Then sat down. The jury didn't know what that meant, but the judge and I did. The defendant was insisting on testifying in spite of his lawyer's advice. The PD wasn't going to assist him in hanging himself. All the guy had to say was, "I wasn't drunk when the cop stopped me. I can drink a lot and not get drunk." That was it. Time to cross-examine. I was kind of taken aback. Our medical expert witnesses had already testified that there was no way a person with a BAC over 0.08 could safely operate a motor vehicle. I thought about just skipping cross. Nah, the jury would be curious. So I abandoned my cross-ex technique and turned into Mr. Nice Guy. I queried him on where he had been earlier that night. Moab. Okay, any drinking there? Oh, hell yes, beer and shooters. Or something like that. Then he and his buddies had piled into the car and headed for Naturita, Colorado. Maybe a 2-hour drive. Any drinking in the car? I asked. Oh yeah, plenty. He was driving, so he held back. Maybe only 3 or 4 beers. Any shots accompany that beer? Yeah, maybe 4. I decided that there was no reason not to let him explain himself after all of that. How is it that you weren't drunk? The defendant explained that he had been drinking for decades and had built up a tolerance. He could drink more than he did and still not be drunk. I thought about that for a minute. Then I asked, "So you're an alcoholic?" Objection. The PD was on his feet. Calls for a medical conclusion. The judge looked at me, then back at the PD. Overruled. He's the one who opened the door. Answer the question. Yes, I'm an alcoholic. I have no further questions. The PD got up to redirect, but it was too late. The defendant had hung himself. Guilty. The PD stomped out of the courtroom. I think he was more upset with his client than me. I just followed orders. The judge ordered him to answer the question. Story 14. I was working a case because I'm a lawyer, and that's what I do. Anyway, my paralegal just had her first kid, so I was alone and had to go into court by myself. She usually refreshes me on each case before we go in, and so I was looking over the papers instead. We were representing a guy who was being charged for cruelty inflicted upon a minor. Not my proudest day, but there was some room to get the charges lessened based on circumstance of the situation and no prior record of him behaving this way. So basically what happened was he was in a grocery store and a kid was pushing around one of the children grocery carts that some stores have, and the child's mom had a real cart alongside the kid. My client comes into the aisle and the 2 carts are blocking the entire aisle, and usually children's carts have little flags that help other people see them. This one didn't, which helped my case a little. He sees the other cart and goes to the other side, not seeing the child's cart, and bumps into it. Apparently he thought that this was the lady's cart because he was looking at cereal and not looking down. When he hits the cart, he pushes because he thought the lady was on his side of the aisle, and this pushes the kid right on his butt, and the kid ends up going to the hospital. Anyway, after the kid falls over and he sees what he has done, he doesn't respond apologetically, and instead asks the lady why they're blocking the entire aisle and why the kid needs a cart in the first place. Meanwhile, the kid has injured his head and is crying on the floor. By now he's ticked, and the kid's cart was pushed forward, and he had room to go through, so he continues to walk down the aisle with seemingly no regret. and ends up running over the kid's hand in the meantime. Now the mom is ticked, because it seemed on purpose. That's the backstory of what happened. So now we're in court, and I'm talking to him, and still seems to not have any regret about what happened, and is mad at the mom for letting the kid have a cart and taking up the aisle. This was a flag for me to not let him talk during court at all, or have him testify. Anyway, the mom is brought on the stand by the prosecution, and she's telling the story of what happened, and all the injuries that this poor kid sustained. I don't remember exactly how many, but a bruised skull, and at least one broken bone in the hand. While she's talking about the injuries, he makes a PFF loud enough for the judge and mother to hear. I'm thinking in my head, oh crap. The mother on the stand, does the mom, excuse me, do you have something to say? And I stand up and say, sorry about that, ma'am, he didn't mean anything. Before I can finish my sentence, he says, yeah. This is where he goes beyond stupid, ruining the case and making things worse. If you had parented your kid better, he wouldn't have been in my way and none of this would have happened. Something like that. The mom responds with a second, excuse me. He then repeats the same exact stupid sentence he just said. By then the judge is slamming his gavel, telling them to basically shut up. The mom responds, no, to the judge, like, I got this, putting up a finger to him. Maybe if you had paid attention, he wouldn't have been knocked over, and maybe if you stayed where you were, instead of continuing on with your day, you wouldn't have ran over my kid's freaking hand. The judge is now freaking out at the both of them. My client then responds, I wish it was you on the freaking ground. I would have made sure it was worse than a couple of broken fingers. What a freaking idiot. The mom is now speechless and doesn't respond long enough that I have time to say as calmly as I could, Your Honor, if you don't mind, could we have a brief recess? I wanted to pull him by the ear and tell him what an idiot he is. Edit. He got off very easy for the amount of damage done in criminal court, the main reason being that it was seen as accidental, and was pretty much accidental. He got community service and a $500 fine with 6 months, very light, ARD, accelerated rehabilitative disposition, probationary period. He wouldn't have gotten anything had he stayed with the kid and apologized after the fact. Story 15. I'm a lawyer. The most ridiculous argument I've seen was one I actually made. One of my clients got busted cooking substances. This was a very clear-cut case. They actually caught him in the middle of a cook. No way he was getting out of this one. Even worse, he was cooking at home and children were there. Yep, the DA, district attorney, loaded him up with felonies. There was no bail, and he was being held in the county jail. My client knew he was screwed. He had been planning to get married a few weeks after he got busted. My client asks me if he can get released for 24 hours so he can still get married. I tell him that I'll ask, but that there's no way in heck they'll let him out. First, I ask the DA if they will allow it. Nope. They laugh. So I file a motion with the court. Now, I knew the judge was a crusty old conservative family values kind of guy, who also has a raging erection for substance crime. There was no law involved, but I put together an argument about the sanctity of marriage and how the state should encourage marriage at all times and that sort of thing. We have a hearing and I make the argument. The DA is totally opposed and calls it ridiculous, and the judge grants it. The judge actually decided to allow my client out for 24 hours to get married. He had to surrender at the county jail at 8 a.m. the next day and some other conditions, but still, he was allowed out. Everyone is stunned. Nobody can believe it. The day of the wedding comes, my client gets out, gets married, then goes back to the jail. Everything went exactly like how it was supposed to, which is also pretty shocking. Story 16. I had a friend that wanted to buy a house but couldn't qualify for a loan. So he asked me to draft a rent-to-own agreement because he said the seller was willing. I advised him not to because those rarely work out. Buyer and seller sign the agreement. I had a feeling Seller would pull some stuff, so I recorded the agreement on the land records in case they tried to sell the property out from under my clients. Fast forward a year or two, and buyer and seller hate each other. Something went wrong in the house, and buyer asked seller to check his insurance to see if it was covered. Seller gave a quick no. Buyer asked to see a copy of the policy, and after some back and forth, seller confessed there was no insurance on the property. That was one of seller's few obligations under the rent-to-own agreement. Turns out the property was uninsurable due to a number of defects, and seller never disclosed it. So buyer wants out and wants to get some money back, which went toward the purchase of the house. Seller countersued for unpaid rents, damage, etc. I represented buyer at small claims court, and we got a judgment for several $1,000s. Seller was a real jerk during this whole process. We were able to learn that she contacted multiple insurance companies way back in the beginning, and they all told her the same thing. Yet she never bothered to disclose that to my clients, who were busy making improvements in the house to make it their forever home. I told my clients not to waste their time pursuing the judgment. The sellers had no assets other than the crappy rent-to-own property and their own crappy property right around the corner. I said, be happy you don't owe them anything. Fast forward another year or two. Sellers are now trying to sell the house outright, and during the new buyer's title search, they discover the rent-to-own agreement. Seller's attorney calls me in a panic, saying they have settlement coming up soon and want to know what it will take to get my clients to sign a release to remove the agreement from the records. I told her it would take paying the judgment in full. She agreed and said they'd pay my clients from the proceeds of the sale. After I hung up, I laughed my butt off. I gotta call my clients out of the blue and tell them I have several $1,000s coming to them. They asked why. I explained that the $1.75 I made them pay years ago to record the agreement finally paid off, how it came up in a title search, and seller could not sell the house without getting the agreement removed, so we had them bent over a barrel. They laughed their butts off too. They were extremely grateful that I had the foresight to do that, and that it came back to bite seller in the butt years later. I still smile when I think about that case. Revenge is a dish best served cold. Story 17. Kind of applies, I'd suppose. I practice mostly criminal defense. I fairly recently had a client who, after pleading guilty to a theft charge, contested the amount of restitution owed. Essentially, the client said, I stole some stuff, but I didn't steal all of that stuff. The victim had to come to court to prove the value of the things he alleged were stolen. Some of those things that my client denied having touched, much less stolen, were rare and valuable coins. To support his claim, he brought a statement purporting to be from a local coin dealer, with the type of coin listed and its value. I knew nothing about coins, but I knew the judge knew a lot about coins, having collected them for years. The DA, district attorney, asks his questions. I muddle through my questions. Then the judge said he had some questions, and verbally ripped this guy's list to shreds. Stuff like, you expect me to believe that underscore blah 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 underscore coin in underscore blah blah underscore condition is worth $250 when I can go online right now and find the same coin for $36? I just sat back like Vincent LaGuardia Gambini while Mona Lisa Vito was being underscore voir dired underscore. It was wonderful to watch. Story 18. I know this is weird, but actual lawyer here. Sitting second chair, complex medical malpractice trial. Stay with me here. In my state, we have wide-open direct examination and wide-open cross-examination, which means the first time up the lawyers can ask any questions, subject to the rules of evidence. But on redirect, you are limited to only subjects covered right before you got up in cross-exam. Then redirect is limited to what was discussed before you, etc. So the first time each side questions a witness, you can cover any subject, but the second and subsequent times you are limited to subjects that the lawyer before you covered. You can't open new doors. Also, you can't use leading questions on direct exam, but you can on cross-exam and redirect and recross. Leading questions are very powerful when you have complex facts to explain to a jury of 12, especially with experts who usually have trouble explaining things to lay people. So there is this super smart hired gun doctor, well known in the legal community, hired by the other side on direct exam. And the young lawyer who calls him has the idea that he will do very short direct and let us destroy the guy on cross, and then he can get back up and rehab him on redirect, where he can ask leading questions about everything we talked about. He gets up and establishes credibility and qualifications and then passes the witness. The older lawyer I was working with then gets up. Lawyer: "Hello, Dr. S. You are looking very fit today. Are you exercising?" Doctor: "Well, yes, Mr. A. I've started biking quite a bit." Lawyer: "How is your wife doing, Dr. S.?" Doctor: "She is great. She just started a new job last week and seems to really enjoy it." Lawyer: "Well, that's great. Thanks for coming down today. No further questions." Thus, the other side was now limited to the above subjects, only on their redirect. The other lawyer turned the color of a tomato as soon as his mistake had hit him. He stood up, asked to approach, and asked for to non-suit dismiss his case. Story 20. My dad was an attorney with a general civil practice. He did a lot of wills, trusts, divorces, and such. He is representing the wife in a divorce. The husband is on the stand. On direct, husband's attorney draws out that husband has a history of violence. Passes the witness. Dad gets the guy on cross-examination and says, "When did you stop beating your wife?" Opposing counsel: Sputter objection. Your Honor. Sputter sputter. As it turns out, opposing counsel had opened the door to past history of violence on direct examination, and you can lead on cross-examination. So it was a totally admissible question. Husband's answer: "Oh, about 6 months ago. Dad told me that that was the highlight of 40 years of practicing law." Story 21. I can't really say I'm proud of this one. It's not a happy case, but it was a pretty sure winner. I represented a client once who had gone through a really rough marriage/divorce several years prior. Child drowned, a couple miscarriages, wife developed postpartum on one, which amplified an existing mental illness. Incredibly sad story. At the time I came into the story, the ex-wife had been in jail for several years, stalking her ex-husband initially, but was still being held because she wasn't competent to stand trial, and I was representing the ex-husband, who just wanted authorization to take over sale of the house so they could finally finish severing ties. Prior to the trial, the wife's pro se briefs made it seem like she was under the impression they were going to relitigate the divorce, filled with allegations related to the marriage itself. Like I said up thread, she already had mental problems, and it was clear she'd picked up some sovcit, sovereign citizen tendencies, during her ongoing incarceration. When it actually came to trial and she was brought in, you could tell she was clearly not well. She was having a conversation with herself while my client was on the stand giving his explanation of the situation. We didn't really have any witnesses to speak of. This was hardly a major matter, so the ex-wife gave her side after that, and that's when the wheels fell off. She basically went on like she had in her briefs, rambling about the divorce itself, claiming my client had committed adultery and therefore she was entitled to 100% of all assets, aforementioned softsit stuff, some general babbling, etc. The judge we had was a nice guy, for which I'm forever grateful. He was patient with her, kind, reminded her that the initial divorce wasn't the issue but generally just let her continue to speak her piece for a bit. After a few minutes he gently shut her down, had the bailiff and guards lead her away, and gave us the authorization. Like I said, it's not a happy, "Oh Lord, we're so going to win this case," just a sad situation, but it was probably my surest winner, other than default judgments. Story 22. Opposing party, mom, stands up while the justice is speaking, interrupts and says, "I can't force my children to do something they don't want to do." For context, the justice was talking about how dad, my client, needed to have some parenting time. Mom had alienated the kids and was claiming that they didn't want to see him. Opposing counsel, who had most definitely not anticipated her client doing this, just lowers her head and closes her eyes. I stand up and say, if mom can't control her children, then perhaps she should not be the primary parent. The justice replies, and I'll be available to hear it when you make that application, Mr. LJ of the law. That said, I knew I had won when mom stood up earlier and questioned the qualifications of the psychologist she had suggested, when said psychologist came back with a report that my client should have parenting time. Story 23. I was being sued by an insurance company from rear-ending a car that pulled out of a parking lot and into both lanes, same direction, in a construction zone that was essentially a cattle chute, concrete barriers on both sides leaving no shoulder. I'm on the witness stand and their lawyer asked what happened, and I told him they pulled out directly in front of me as I was traveling about 40 miles per hour, and they straddled both lanes leaving me nowhere to go, so I hit the horn and brakes. So he asked me, so you are saying when my client pulled out in front of you, you had time to use your horn and use the brakes, but couldn't stop? Did it ever occur to you to simply apply the brakes and not waste time using the horn? Don't you think you would have avoided hitting my client if you did that? I couldn't believe the question. I answered, well, since you've admitted your client pulled out in front of me, I can admit to something too. I can hit the brake and horn at the same time, just like I can pat my head and rub my tummy at the same time. See? And proceeded to demonstrate. I was found 0% liable. Story 24. I thought it was pretty strange at the time, but later found out what the strategy was. What the defendant's attorney said when it was time to present their case was, "The defense rests." That was it. Deno attempt at all to rebut the mountain of evidence that had been presented by the prosecution. I was the jury foreman, and in the jury room, guilt was a foregone conclusion. However, in Virginia, where the trial occurred, the jury also determines the sentence, and that's where we had issues. A couple of jurors wanted a very light sentence, so as not to ruin defendant's life. In the end, the rest of us prevailed upon them to impose prison time, although not as much as most of us would have liked. After delivering the verdict and sentence, I expected that we, the jury, would be released. Instead, the judge asked us to meet with him in the jury room, where he praised us for doing a better job than he had anticipated. We all left, not knowing exactly what he had meant. Years later, an attorney friend explained to me what had happened. The defense attorney knew that jurors don't get to see any kind of sentencing report, i.e., a list of the defendant's prior arrests and convictions. So the defense's whole strategy had occurred during jury selection, where they'd tried to get at least one or two jurors who seemed to have sympathetic views towards criminals, seeing them as victims rather than predators. And it had worked, to an extent. The judge, who knew that the defendant had a record a mile long, expected us to give him community service and/or probation. The fact that we'd returned any prison time at all gave the judge the latitude to impose a sentence more fitting for the crime. Story 25. Because of various professions in my time, I have seen a lot of court action and find defense lawyers to be a very special breed. Many moons ago, late 90s, I was a mobile patrol security guard in Sydney. I rang up and reported a very drunk driver who nearly hit me and was all over the road. How they didn't crash still amazes me. I was still on the phone to the cops when they pulled in to their home. I waited, and the cops arrived pretty quickly. The driver admitted to driving the car and was breath tested and came back at .21. Fast forward a few weeks and the cops come to me and say the driver had put in a not guilty plea at court and asked if I would attend court as a witness so they could proceed with the case. Absolutely, I detest drunk drivers. The entire defense was based around discrediting me and saying she had been at the home for about an hour drinking, and for some reason I had a vendetta against this woman to ruin her life. Her version of the evening was full of holes, while I had records from the patrol wand and CCTV from my last hit, which showed her driving past as I left. Even with all this, the defense lawyer doubled down and just started insulting me on the stand, for which the magistrate told. Story 26. Once successfully defended a suit based on the statute of limitations because the plaintiff filed it too soon. Fact pattern. plaintiff filed suit against my client in state court and against others in federal court. A year later, plaintiff voluntarily dismissed both suits and refiled in federal court, combining the two suits, minus a non-diverse party that had settled out. At the time of dismissal and refiling, the statute of limitations had run, but plaintiff relied on a one-year saving statute. Plaintiff filed a notice of dismissal of my client's original suit on December 8, and later that same day filed the new suit in federal court. However, the state court did not enter an order dismissing the suit until December 11, noting that the dismissal was nunc pro tunc to December 8. I prevailed on the argument that the nunc pro tunc designation was ineffective, and the new suit was therefore filed before dismissal of the previous suit. The saving statute only saves suits filed within 1 year after dismissal of a previous suit, so the plaintiff's suit was barred by the statute of limitations. Story 27. Edit. Cross-claim, not counterclaim. Duh. Successfully got a cross-claim dismissed at MTD, motion to dismiss, on a paradox. I had a client with a commercial lease through a corporation, run by her and her daughter. The client's husband, who was undergoing chemo, guaranteed the lease. He died about 9 months later, and she defaulted on the lease, so the landlord came after the estate for the money. The estate, his adult children from a previous marriage, alleged fraudulent inducement by my client, taking advantage of her dying husband to get him to guarantee the lease as a defense to payment, and brought in my client as a third-party defendant. If the estate successfully proves fraudulent inducement, then it doesn't have to pay damages to the landlord because it was relieved from the guarantee. If the estate doesn't have to pay damages to the landlord, then they have no damages as a result of my client's fraud, and therefore failed to state a cause of action for fraud. Conversely, if the estate can't prove facts amounting to fraud to get out of the guarantee, then they also can't prove a cause of action against my client. Story 28. While clerking, I sat to the side of the bench, where I could see the judge's face and the rest of the courtroom. My judge finishes yelling at someone, and as often happens, this huge vein on his forehead is just pulsing. Well, he apparently asked me a question, and I missed it. He then raises his voice, calls me by name, and asks if I'm awake over there. Without thinking, I responded a bit too truthfully, and said, "I'm sorry, Your Honor, I was trying to calculate your pulse by timing the vein on your forehead." He stares at me, barks out a single laugh, and then repeats the question. I thought I was so dead, but afterward he was laughing about it on the way back to chambers. Story 29. In my defense, I was very frustrated at the time I said this. Defendant pleaded guilty to a domestic assault, and a particularly lazy and unpleasant judge wanted me to waive a presentence investigation and sentence the case immediately. After some back and forth about my objection to that course of action, I explained that the Crime Victim Rights Act and other statutes required the PSI presentence investigation. She glared at me and snarled, "Thank you for explaining the law to me." I replied, "My apologies, Your Honor, as your question implied you were ignorant of the statutory requirements." I thought she was going to hurl her gavel at me and/or jump over the bench. Story 30. This is going to be buried, but I've been waiting to tell it outside my friend group for a few years. I used to be a judge advocate in the Marines. As such, we had a lot of cases where counsel may be in different places around the world, meaning most hearings would be on video until the actual trial. Well, one time there was a case in Hawaii, and all the counsel, except for me, were in Hawaii, with just the judge and I being CONUS, Continental United States, and at the same base. The courtroom at the base where the judge and I are stationed is having issues with its video teleconference system, so about 30 minutes before the motions, hearing the judge emails all counsel to let them know that she will be conducting the hearing from chambers so that there is a reliable video and audio feed. She concludes with, "Captain Penoyer, you are welcome to come to my chambers for the hearing so that we minimize the risk of any additional tech issues." All right, sure. She's a pretty good judge, and we have a good working relationship. Still feels weird to just be in chambers with a judge, who was also much more senior to me in rank at the time. but I'm not going to decline and then get murdered from the bench if I have a tech issue mid-hearing. The other side makes arguments from their courtroom, and it's now my turn. The judge turns to me, anxiously sitting in a too small and uncomfortable chair on the other side of her desk. Captain Penoyer, do you have arguments you'd like to present? And of course my brain's desire for normalcy/formality and urge to make jokes combine for my favorite line. Yes, Your Honor. Permission to kneel before your desk and make arguments? Instead of, enter the well. You may proceed, counselor. Champagne, if you're reading this, you're still my favorite judge from those years, and I hope to bump into you in the real world one day. Thanks for all of your hard work and mentorship of young judge advocates, both before your time on the bench and when you were doing it from the bench. Story 31. Years ago, I was in a jury trial in a wrongful death case, with the death occurring next to a rural city park. We challenged plaintiffs' planned use of photos showing other parks in the city that were fenced. We went back and forth on it with the judge, and ultimately he decided the conditions were not sufficiently similar and excluded the photos. He made clear that it was his final decision. I was standing at counsel table waiting for the bailiff to summon jurors, when suddenly I heard plaintiff's attorney yelling about the photos. He had grabbed them from counsel table and ran up to the very edge of the bench and was pushing them in the judge's face, yelling, "You're telling me you're not going to let the jury see these photographs?" The judge looked shocked, and then it caught the bailiff's attention, and he unholstered his firearm. I seriously thought I was going to see opposing counsel shot dead in the middle of trial. Story 32. I have so many from when I worked in the clerk's office. So many. The first that comes to mind isn't necessarily crazy or odd, but just absolutely hilarious. We had a one-day hearing for an estate case, where there was a common-law marriage dispute. Essentially, the deceased had lived with a man for several years. At the funeral home, the man tells the woman's sons they were common-law married, and it's an absolute shock. The judge and both attorneys either grew up together/went to law school together, or had a standard tea time weekly. All get along very well outside of the courtroom. Attorney for the sons, Giant, is 6'7", very soft-spoken, and has a bad habit of standing at counsel table, and the court reporter can't hear him because he's so far away from the mic. When Giant gets mad, he gets mean. Attorney for the man, Gnome, is 5'7", loud, and has a bad habit of wandering around the courtroom, not talking into a mic at all. Really likes to stand directly behind opposing counsel, yelling at the back of their head. When Gnome gets mad, he starts hopping up and down like an angry little dun gnome. Court reporter has to interrupt constantly to tell them they need to talk into the mic. Hearing ends up lasting 2 days, and everyone is very burnt out and tired. It was very tense and miserable. Gnome offers an exhibit that was a picture of a wedding ring. I don't recall why, but Giant objects and judge doesn't admit it. Gnome visibly pouts for a solid 3 hours, leaned all the way back in his chair, with his arms crossed and lips stuck out. I wish I could adequately describe just how petulant he was. Judge finally stops in the middle of a witness, looks at Gnome and says, "Mr. Gnome, what is your deal?" Gnome throws his arms in the air and says, I'm just still mad at you for not admitting my exhibit." Judge in a deadpan, "Mr. Gnome, grow up." We finish the hearing, and judge finds a common-law marriage did exist. Literally no reason to pout over an exhibit for 3 hours. Story 33. I prosecuted an aggravated robbery case in the late 90s, and the defense attorney was trying to get the jury to convict of just robbery by arguing that the weapon was not a deadly weapon. The robber had used a heavy Maglite flashlight to beat a store clerk. During closing arguments, the defense attorney hit himself in the head twice with that flashlight to show that it wasn't a serious weapon. He didn't knock himself unconscious, but it was clear that he seriously injured himself and couldn't finish his closing argument. He pretty convincingly proved that it was a deadly weapon, and the jury didn't take long to come back guilty of the higher offense. This video does not promote illegal activity. Stories are shared for commentary and education.